To begin our second panel, I'm going to introduce Michelle Van Cleave. Michelle's an old friend who has great experience in both the executive and legislative branches of the U.S. government. For many years, a senior aide to Jack Kemp on the House side, Michelle later was staff director of the Senate Judiciary Subcommittee on Technology, Terrorism, and Government Information. She later served as the assistant director of the White House Science Office, and more recently as the National Counterintelligence Executive of the U.S. government. Michelle, I'll welcome you to begin the panel.
Thank you, Herman. I am very grateful for the opportunity to moderate what I know is going to be a fascinating discussion, but I fear if I'd actually told Herman about my background in law school when I was a first-year law student and the hellacious arguments that I had with my constitutional law professor over this very subject and the horrible grade that I got as a result, may not have invited me to moderate today, but I'm especially pleased to have the opportunity to do that, and all the more so because of the two discussants that Herman has invited to address the issues that are before us today. Secretary Chertoff, Judge Michael Chertoff, served as one of the second actually, Secretary of Homeland Security Department, where there were certainly lots of questions that surrounded the country and his tenure about what to do and how to do it, where the questions of responsibilities between the president and the Congress certainly were addressed in an ongoing manner. His service also on the court and as a prosecutor and in the Justice Department gives him a rich and wonderful background for the conversation that we are about to have today. Senator Kyle has had long service, as all of you know, in the House and the Senate, 8 years in the House, 18 years in the Senate, including his service on the Judiciary Committee, where I was so privileged and honored to have the opportunity to work for him, and his last 5 years as whip in the Senate, in a position of leadership where he was rightfully known as someone who was a master of substance and a very serious scholar. Both of these gentlemen, lawyers both, thoughtful people, experienced people in the area that we are going to discuss today, and so I expect a very interesting discussion. If those of you who heard the last conversation may have noticed the richness and the depth of the questions that attend this challenge in the Constitution as between the responsibilities of the executive and the Congress over foreign affairs and national security. We're going to try in this panel to speak to some of the current and pressing issues where those questions have practical application. But before we begin, I would like to ask each of our discussions to take just a moment, three or four minutes, to present your own perspective on where you see this significant framework and how it outlays the responsibilities of each branch the way that you read the Constitution and from your experience.
Thank you very much, Michelle. I think it is useful to look at this from an overview perspective, and since I'm supposed to defend the position of the Congress and Judge Secretary Chertoff, the President, let me lay out the thesis from my perspective. It is simply that we have more to fear from presidential outreach, or overreach rather, than from the other two branches of government. And therefore, in evaluating any question of whether the Congress or the President has the authority, or in some cases the judiciary, we should be more vigilant when we come across cases where the President has asserted his authority. And sometimes it's necessary to try to take action to deal with that. And here's the reason. The Constitution obviously sets out very general authority. And the reason it's worked so well in terms of the separation between the branches for over 200 years is because the branches have given the other branches deference. They have been restrained in their actions by and large. There's been a great deal of comity, and usually there's been an adherence to tradition. Not always. But to the extent it's worked, I think this is one of the reasons why. In international affairs, of course, the presidency has dominance, and there are a couple of key reasons for this. First, it's a lot easier, more effective for the president to act. He's one person, much more easy than 535 people trying to get their act together. And the previous panel indicated some of the other reasons why it's just easier for the president to represent the American people. And secondly, I would assert that there are far few effective checks and balances on the assertion of presidential power than there are for the other branches to act. The last two presidencies and maybe the last three presidencies have, I think, verified the validity of this assertion that I'm making. Consider briefly the checks on the Congress. First of all, you have to have both houses to act. If you're going to pass a law, you also have to have the concurrence of the president, maybe the person whose actions you're trying to check. That's not going to be easy. Both political parties are represented in both branches of government, and the executive only one. There's also something that I think Michael could speak to much better than I, but all presidents, Democrat and Republican, have White House counsels that have one main job in their view, and that is to assert the prerogatives of the president, and they all do so very effectively and I would say with some degree of extremeness. The checks on the president are much weaker in my view. First of all, there's the vaunted power of the purse. What is the power of the purse? For Congress to pass a law, that means the president has to sign it. So the power of the purse, which is to appropriate money, is only effective if the president agrees to be bound. And frequently those are one-year obligations. So the president you're seeking to be bound is the president who would have to sign the law. So that doesn't work very well, as members of Congress have found out. Impeachment was much overrated by the founders. It just doesn't work very well, and we all have recent experience as to why that is the case. And the courts rarely want to engage in refereeing disputes between the two branches. As a result of which, really the only power or the only check is in the people. In the case of a president in his second term, there's not a whole lot of accountability there. It generally spills over into the congressional races. So there's not real effective restraint on a president who wants to assert authority and is willing to thumb his nose at either the Congress or the courts in order to do so. And that's why I suggest that if we're evaluating the question, and by the way, on virtually every one of the questions that Michelle is going to ask, one can make a pretty good argument that there is a role for both the Congress and the president to play, sometimes even the judiciary. And it's just a matter of the gray area in between as to who has the preeminent authority. So my thesis is that when you're examining these questions, if you're concerned about too much authority being exercised by one branch or the other, one ought to keep a very close eye on the president. It's just a lot easier for him to take on excess authority than it is for the Congress.
Great. Well, I'm not sure you're going to get a lot of disagreement on this panel, but let me give you my kind of overarching sense of the framework. If I look back at the Constitution, I see Congress's power in the area of foreign affairs and military as largely being money, the ability to appropriate. The rules that set up the organization of the military, to create the Army, the Marine Corps, the Air Force, and the structures within those military departments, and the ability to confirm personnel. Those are the three major levers. They're both rather, I wouldn't say clumsy necessarily, but they're kind of big levers. They don't lend themselves to fine-tuning. On the president's side, I think the president gets a lot of deference with respect to the actual operational execution of foreign policy and military policy. And just to give you a couple of cases, and this is probably going to exhaust the limit of my scholarship, on the issue about declaration of war, it turns out that when you have fairly serious conflicts, including conflicts that we would currently describe as asymmetric, the courts have generally viewed the president as having a great deal of power to act autonomously. And the classic example of this is the prize cases, which had to do with the blockade of the South by the president during the Civil War. it was challenged ultimately in court, and the court said that the president had the authority to exercise military force against the South, even though the South was not recognized as a nation, and even though there had not necessarily at the time of the cases arose been a declaration of war. Likewise, with respect to the recognition of foreign governments in the context of diplomacy, Goldwater versus Carter made it clear that the president really has plenary power in those areas. So to me, the Congress sets the table in terms of money, organization, and personnel, and the president really operates most of the levers of actual execution. I think there are occasions when both branches have worked well together, and the example I use is 9/11. I was the head of the criminal division at the Department of Justice. I was very much involved in the immediate response. We spent a lot of time on the Hill. We passed the Patriot Act, and there was virtually unanimous support in Congress for what the president was doing. In fact, I would argue that a mistake the Bush administration made was some of the things which were done by executive action could have actually been done with the consent of Congress, which would have, first of all, eliminated some of the legal uncertainty which you read about with respect to surveillance, and also would have created a kind of a political basis of support that I think would have stood the president in good stead as time passed and we moved out of the initial sense of solidarity into a little bit more of politics as usual. But I would also say that Congress is often relatively dysfunctional in exerting its power. And for example, even the power of the purse, forget about what the president does in terms of a veto, even getting budgets passed has been very difficult for Congress. We often wind up with hostage taking, where one party says, if you don't give me everything I want, I'm not going to let anything pass. And that of necessity drives the president to take action on his own, particularly when you're dealing with dynamic circumstances. So I think that we're at a stage now where there's been an accretion of history that's been built up over time. I do think if we could move back to a regular order of Congress, where Congress could really pass budgets and use the appropriations power more effectively, that would actually both restrain the president to some extent and also encourage the president to deal with Congress more in dealing with some of these issues, particularly regarding the use of military force.
So that gives me a perfect lead-in to begin to ask the questions. Both of these gentlemen have agreed to allow me to present questions which they will answer. I think it's a tribute to leap year and leap day. So that's what we're about to do. So let me pose the first question and perhaps start with you. Senator Kyle will alternate on addressing these questions, but it is raised by Secretary Chertoff's last comment with respect to the use of military force. Today, do we need a new authorization for the use of military force with respect to prosecuting the actions against ISIS and ISIL?
It's a good case to illustrate the reason why we need some degree of deference and comedy. This president wants a declaration of or an authority to use military force that is greatly constricted, that would limit a future president dramatically. The Republican members of Congress do not want to do that. So you have a conflict between the two branches as to what kind of declaration would be appropriate. Yes, it would be useful. One can argue that under the general construct of the Constitution, it's really necessary in one form or another. And probably that latter requirement is satisfied by the original declaration, which everybody sort of agrees is generally applicable, although it would be nice to have something a little bit more specific. So both branches are moving forward, even though I think both of them recognize it'd be better to have something more up to date, because they recognize that politically this is just the way it's got to be.
Judge.
I think it would actually be helpful, but I agree. I think that we're in the unusual situation where it looks like the president wants something that is more constraining, particularly for future presidents, and the issue he's having with the Republican Congress is that they want to give more latitude. But in general, I would say that if you're going to engage in persistent long-term use of military force, getting congressional support. You can debate whether it's legally essential, but I think it's politically helpful.
So it sounds like you both have the same perspective on this, that while it would be
And I'll even go
useful,
one
yes.
step further. Though I was a strong supporter of the executive's authority in the Bush administration, and I told Michael outside, on these general issues of the respective powers of the president and Congress, it's pretty much where you stand is where you sit at the time. We've almost all been on both sides of the issue, depending. But I very much agree with Michael that in the case of the early actions in response to 9/11, it would have been preferable had the administration been willing to engage Congress. I think Congress would have passed something that was very workable, would have been fine with the president, and it would have saved some trouble later on. Probably wouldn't have avoided all of the issues that arose later on, but it would have been a tidier application of both parties' power under our Constitution.
Well, then, picking up on that theme, let me change subjects on you and ask about the agreement with Iran that was concluded recently. There was a lot of back and forth as to what the appropriate role of Congress was in reviewing that agreement. It came down to a resolution that brought the agreement before the Congress. But there's also a treaty-making clause and treaty-making powers that are in the U.S. Constitution. And I guess a generic question as we begin to discuss the Iran agreement is, when does an international agreement fall under the treaty-making powers conferred by the Constitution? How do you delineate that?
Again, not pretending to be a scholar, I would say this. A treaty is a law. So, for example, if you have a treaty and it follows a statute, the treaty trumps the statute. And therefore, it has the force of law. An executive agreement, as I understand it, does not have the force of law with respect to statutes. Under the Supremacy Clause, it probably preempts state action, but therefore it has limited utility. I think in this case, it's an example of the fact that without a treaty and without congressional support, this agreement is very weak, and it is subject to being revoked on the first day of a new presidency. So if you're trying to make decisions about investing in Iran, putting aside the wisdom or lack of wisdom of doing that, the ability to depend upon the existing state of legal affairs in the absence of a treaty is very fragile. And I think we've seen in a lot of respects, you've seen executive action that, because of the fact it doesn't have the durability of a statute or a treaty behind it, winds up being very fragile, and therefore it's not something people can count on.
I agree. I don't think that there is any case law that defines this question of where is the bright line to say that that's a treaty and that isn't, and therefore you have to have 2/3 concurrence in the Senate for this, but you don't over here. You also have in our history a variety of ways in which these questions have been dealt with. Sometimes Congress, both houses have passed something, and that's exactly what they did here. They kind of flipped it and basically said as long as the president can get 1/3 plus one of both houses, he can veto whatever Congress should do contrary to my will here. So you've had everything from a requirement of a treaty with 2/3 concurrence by the Senate to congressional action of one kind or another with the participation of the president to nothing. And I think the enforceability and the desirability is almost in inverse proportion there to what we talked about, at least if you're talking about a very serious matter. And I think you could clearly say that the Iran deal was serious enough to have risen to the level of a treaty. It would have been desirable to have the Senate approve it, but the Senate wasn't going to approve it. And so the president decided to do something much less than that. So he should, and the people who support him should be not surprised if later a president tries to undo a great deal of it. But here's the point that I would make. In the meantime, one could argue that some damage is done. Now, first, I'm not arguing that this was a treaty that had to be submitted to the Senate, but I'm saying a very good case can be made for that proposition. I don't think there is law that decides it one way or the other. But I also fear presidential action which time and time again, over a long period of time, asserts the ability to do these kinds of things, changes the circumstances on the ground and makes it very difficult for a successor to try to do something different, because history is being made in the meantime. Relationships are established, circumstances change, commitments are made, allies are trying to rely on you, maybe. It makes for very messy understanding of how the American government is going to act in the future. It would be better if there were a little bit more deference and adherence to a little bit clearer set of rules by presidents of both parties.
So I'm left with something of an uncomfortable sense that, listening to both of you, that the constraints on the president's discretion to decide whether or not a particular agreement meets the standard of submitting to the Congress or not is plenary. And that other than the political checks on his discretion, there are no statutory or other checks on his discretion.
Well, there could be some statutory. Remember, all legislative power resides in the Congress. There's not a distinction between legislative power relating to international affairs versus legislative power relating to domestic affairs. So as Michael pointed out, Congress does have some rather blunt instrument power in making, in setting up some legislative constraints or legislative authorizations. In this case, there are already pre-existing laws relating to existing sanctions and how those sanctions can be removed or not removed and so on. So Congress still has a role to play here, but it makes it difficult for Congress to do that. So I think it gets back to the central point here that the framers left, first of all, I doubt that the framers really even anticipated some of these things, but what they did anticipate was human nature being what it is, presidents and members of Congress being what they are, there are going to be gray areas here, and they counted on people of goodwill to work these things out and to exercise some deference. And all I'm saying here is a case where probably, at least in my view, in a perfect world, the president went further than he should have.
So, Judge, would a future president have the unilateral authority simply to terminate this, as some of the candidates have suggested they would?
I think from a U.S. legal standpoint, you could terminate the agreement. I think the issue then becomes, from an international standpoint, I think part of what the people who supported the agreement were thinking was, once this is established, just a unilateral repudiation of the agreement would cause a falling out with our allies. And so I think, as John said, sometimes this is an effort to create facts on the ground, on the theory that although the next president is not bound by the agreement, it becomes difficult, given international relations with allies, to simply abandon it. So I think that's really the dynamic here.
Well, let me change the subject on you and ask about something that's very much in the news, but has long been something President Obama has made a hallmark of his presidency, his objectives. In his second day in office, he issued an executive order entitled Closure of Guantanamo Detention Facilities, and has recently put forward a plan in order to carry that out that I guess the Congress is now considering. And so let's talk about that subject, if we might. I am curious about a number of things. For instance, I'd like your views on whether the Congress has the power to decide where detainees may be held, or when they're brought to trial, whether the courts of jurisdiction shall be military or civilian, and if there are any limits on the president's authority to release detainees as he may choose.
So let me try to deal with each of these in turn. I think the president's ability, his legal authority to release detainees or transfer them overseas, is pretty plenary, because I don't think Congress has laid down a requirement or a statute that says you can't ever have anybody leave Guantanamo. Different story when it comes to bringing them to the U.S. As I understand the law, it's quite clear the president does not have the authority to bring any of these detainees to the U.S. And, in fact, there's a prohibition against expending money for that purpose. And that brings me to one of what I think are the powerful tools Congress has, which is the appropriation power and the Anti-Deficiency Act, which says if you spend money in a way that's not appropriated, it's not only an administrative violation, it's potentially a criminal violation. And my recollection when I was in the executive branches, people took that pretty seriously. One of the things that a subordinate officer would not do would be to carry out a violation of the Anti-Deficiency Act that would expose him or her to actually being prosecuted. So I think it'd be very tough, given the existing state of the law, for the president to bring or transfer any of these detainees into the U.S. As to whether to choose to bring them into a military commission or a federal court, again, I think the structure for these is largely set by Congress, which does have the authority explicitly under the Constitution to set the rules for capture and land and naval warfare. But I think as between those two venues, the president has the executive power to decide where he's going to try somebody. I think the effort to bring some of the 9/11 defendants into New York, however, ran into a political buzzsaw as a practical matter, and that's why I think that's not going to happen.
I think there are really two questions here. Start with the anti-deficiency aspect of it, and Congress limiting the president's ability to expend funds, in this case to transfer prisoners. That was accomplished by virtue of an interesting political process. Both the Congress and the president needed to have a final appropriation bill for the year to fund the government. And there were a lot of trade-offs in the bills or the continuing resolutions. It's gone now for several years. And the political exigencies were such that the president was willing to sign that legislation. So he was willing to bind himself not to expend money to transfer these prisoners to the United States. And that continues because of the continuing resolution which was passed. So if all we do is pass another continuing resolution, that limitation continues to apply. So on that, the president is bound. I would raise the interesting question, even though members of the administration that Michael served in took this seriously, should President Obama not take it as seriously, would his Attorney General decide to take it seriously or not? See, it does depend on other people taking action to enforce the law. And under current circumstances, you can ask a question as to whether that would be done or not. The second interesting aspect of this is the congressional authority to deal with the capture of forces on land or sea, the prisoners of war or the people that are captured in a conflict. At the end of the day, Congress, after the court said that some of the things the executive was doing were unconstitutional, did set rules for the detention and interrogation and treatment and appeals of habeas petitions and the like for the people at Gitmo. And that's probably, at the end of the day, the way that it should be. That is to say, it started out with President Bush just using his commander-in-chief powers to take these prisoners, interrogate them, put them someplace, and so on, and eventually declared military commissions that took a long time to get off the ground. He can do all of that. It's better that the Congress set the general parameters for the president then to execute the laws in furtherance of that. And the court had to get involved in this as well. So you can see how, again, it would have been better had the Congress been willing to assert its authority early on, had the president been willing to go to Congress and try to work that out. I don't remember whether he could have done that at the time politically or not. But in any event, he took unilateral action. The court in part upheld it, and court said, no, there have to be some habeas procedures here, and then Congress stepped in and provided what those habeas procedures were to be. So it's really a casebook example in two different respects of how all three branches have to work together in some of these areas, and eventually we sort of get it right, even though there may be some missteps along the way.
So just to be provocative and extreme on this, as we move away from this question, if, hypothetically, President Obama were to decide, notwithstanding this conversation we just had, that before he leaves office, he is going to close the facility and he's going to transfer or release those detainees, is there anything that Congress could do at that point to stop him?
I'm not sure Congress could stop it, but I do think what would happen is the subordinate officers who would be required to expend the money would ask themselves whether the next president is going to honor that and whether the next Attorney General might prosecute them. And I think you might have a situation where people would decline to execute.
I think one of the questions that's not answered, I mean, I can't answer it, is whether expenditure of funds to transfer out of the country trumps the, I would say, pretty plenary authority of the Commander-in-Chief to deal with the people that he's captured and held, although that is still subject to a plenary authority of Congress. But Congress, I don't think, was explicit saying, and by the way, you also can't transfer anybody to Saudi Arabia. It hasn't done that.
Yeah, I may be wrong, but I think the prohibition is against transferring into the U.S. I don't think there was and I think there might have been a constitutional issue prohibiting the transfer out of the U.S., but I think certainly prohibiting the transfer into the U.S. is I think, constitutional.
Well, let me try one that maybe is a little easier. With respect to recognition of foreign governments. Last year, the president opened up diplomatic relations with Cuba, which had been severed since 1961. So, should the Congress have had any role in that decision, whether under the constitutional allocation of its responsibilities or politically? And does the Congress have a role in its implementation?
You win this one, Michael. Go ahead.
Well, I think Goldwater versus Carter makes it clear that the president is unconstrained in his ability to recognize a government. But I think when it comes to lifting the embargo, there are certain parts of the embargo that are statutory and certain parts that are not. So I think the president has the power administratively to modify those things that were administrative action, but does not have the ability to change elements of the embargo that are part of what Congress has previously enacted, which is why I think he's argued that Congress ought to change the law.
Are you going to get into the requirement that the State Department note the birthplace of Israeli citizens in Jerusalem? Are we going to talk about that?
I think we're talking about it right now.
Well, okay, because this would be a good time to bring it up. Congress passed an act called the Jerusalem Embassy Act in the early 90s, mid-90s, 1995, I think, maybe 6, which said that the U.S. Embassy in Israel should be relocated to Jerusalem. There was a presidential waiver that was required to get the bill passed, and every president since has taken advantage of that waiver, not to do what Congress mandated that he do. Again, but legally, because there was a waiver provision in there. The Congress then declared that because a person born in Jerusalem, Israel, would like to declare on the passport birthplace Jerusalem, Israel, that we'd ought to recognize that, and the State Department should issue the passports that way. And the court, in I think it was 6-3 decision, upheld the power of the president to ignore that. And Roberts wrote a dissent, which I thought was pretty powerful. But there you have an interesting question of in the sort of the lesser issues, not recognizing another country, but administering some laws here. Was the president correct in ignoring this law? It also gets in a little bit to the question of signing statements, because the president signed legislation, but after criticizing President Bush for this horrible practice of making signing statements, namely that I'm going to sign this, but I think parts of it are unconstitutional, and I may not enforce them if I ever get to that point. This president did exactly that. And it's an interesting case. I think it's 6-3. I would have been on the side of the 3 because I helped to pass the legislation, but it's another illustration of how you've got a real tension between the two branches here. It can get into fairly minute details, and there's no real easy answer.
And this may be a rare area where we disagree. I think I'd probably go with a 6 on this, because I think the question of how you denote something in terms of whether something is recognized to be part of a particular geographic region or not does have relational impact in terms of our foreign relations and our dealing with other governments. This comes up often with the issue of Taiwan and China, which is where Goldwater and Carter came up. Because there, if you were, for example, to I don't know what the passports look if you're, born in Taipei, but I could easily see a similar issue arising. And that to me strikes me as the kind of micromanagement issue that really is committed to the president and not to Congress.
Let me, since we finally have one little teeny area of disagreement here, let me carry it out. We'll milk this for just a little bit. But here's the argument on the other side. All legislative powers, not except in international affairs, are set forth for the Congress. The president has no legislative authority. His authority is to take care that the laws are faithfully executed. Congress passed a law. The president didn't faithfully execute it. Did it or could it have relational impacts, or I forgot the elegant way that Michael put it? Yes, absolutely. Did it complicate the president's dealings with countries that would disagree with this proposition? Complicate maybe his dealings with the country of Israel? Yes. Should that matter? The president is not dictator when it comes to international affairs. The president is supposed to carry out the laws passed by the Congress in this relationship, even if it may be uncomfortable for the president in carrying out what everyone would acknowledge are very legitimate functions of the presidency, which in many respects are, as I said, more defensible, particularly in this era of such globalization and need for speed and need for unitary action. Nobody can argue the president shouldn't have predominant action. And, well, but does the president any more than the Congress care about these relations? We have a Foreign Relations Committee, an International Relations Committee. Congress spends a ton of time dealing with other governments and trying to help set foreign policy. Foreign policy isn't just set by the president. So I think you can argue that one both ways.
I think the issue would be probably the people in the executive branch would probably say the question is, would it be constitutional to prescribe the way the passport has to be written? And I think that's, gets to the issue of, there is clearly some constitutional limit on congressional power in this area.
So to push the envelope on this one, if a future president were to decide to recognize a Palestinian state, would the Congress have any say?
Well, I think that's, if I'm not mistaken, I was clerking the year Goldwater was decided. I think that's what Goldwater v. Carter was. It was basically, there was a restriction on the president's ability to, in terms of how he dealt with Taiwan, and the president ignored it and went to the Supreme Court, and I think the court refused to, actually upheld the president's power. I think, wise or unwise, I think this would be the president's prerogative.
I think that's probably true because there's no real easy way to check it. That one, so what would the standing question be to challenge it in court? Who would have to say?
There's a standing issue. Some of it's a political question issue. I'm trying to remember the various opinions in Goldwater versus
I don't
Carter.
remember the standing question.
Yeah.
At least recently, the court seems to have grappled with this question in one context and said the body itself might have standing, but an individual member wouldn't have standing to assert certain things, maybe not in this particular question. Congress would, of course, have some power of the purse issues there, but again, the president would still have to sign the legislation, but there would be enough other blunt instrument. Michael mentioned the blunt instrument checks. These are not ones that you like to use, but refusing to confirm executive branch positions or ambassadors, that kind of thing. You don't like to do it. It is a really blunt instrument, but sometimes it's done and sometimes it can work.
Yeah, by the way, that brings up a notable decision of the Supreme Court on the appointment power, the president's ability to appoint people without confirmation, which came up in the, National Labor Relations Board when a whole bunch of people were in there and the court ultimately said they have a quorum. So I think there's a little bit of a yin-yang to this relational thing between Congress and the president.
So let me move on to something that's near and dear to my heart, the question of intelligence collection. There's been a great deal of conversation about NSA and various permutations of that discussion, I think are worth having, but let me start with the foundational question that asks, under the Constitution, does the president have inherent authority to authorize intelligence collection against foreign entities operating physically or virtually within the United States?
So I think operating physically within the U.S., there is, Congress can limit that, and that's what FISA's about. And that was the Keith case, I guess, U.S. versus U.S. District Court. I think if you're dealing with foreigners overseas, I think the president's basically got plenary power, and I think there's a Fourth Circuit case called Truon that says that. And then you get into a kind of a murky area domestically, particularly in the area of virtual activity, and that's a lot of the debate you see now with respect to metadata collection and whether it violates FISA. I think most presidents have taken the view that they will follow statutes relating to collection within the U.S., whether it's of foreigners or U.S. persons, or overseas if it's U.S. persons. I'm not sure they would take that position with respect to foreign collection against foreigners.
I agree, and I don't think they should. I think the president does have plenary authority there. This is one where I'd rather switch sides with Michael, but I think he certainly stated the law well. And by the way, Secretary Chertoff was a witness before Congress, before the House Judiciary Committee last week on this exact subject, and you might ask him a little bit about that.
You're so asked.
Yeah, so the issue there is, which is, is whether under ECPA, the Electronic Communications Privacy Act, the U.S. government can directly issue a warrant against a provider in the U.S. for emails that are held in a server overseas. And it's an area where it's currently being litigated. Putting aside how that case actually comes out, I guess the view I took there is that as a matter of comedy, international comedy, we ought to take the position that it's similar to like searching a safety deposit box held in a bank in Ireland. While a U.S. court should be able to subpoena a bank for the bank's own records, searching a safety deposit box in another country, I question whether a court has the authority to issue a warrant to search something in Ireland. I think the Irish authorities would laugh at the writ. So the question becomes then, can you work out an arrangement with the treaty process where if it's at least a non-U.S. person, you have to go to the authority in the country where the server is located and use the MLAT, hopefully more efficiently, in order to get the information. If it's a U.S. person, you could presumably proceed directly against the U.S. person by way of something more akin to a subpoena, although you're going to have Fifth Amendment issues and things of that sort.
The issue is complicated by the fact that the government claims that while the particular computer may be located in another country, all that has to happen is for the recipient of the warrant to press a button in the United States and the computer coughs the stuff out. So the fact that these things are now, they're getting so technologically integrated worldwide is creating a whole new set of issues that are really interesting.
Very true.
So at the heart of the conversation about NSA's collection of metadata here in the United States under the 215 program, when that was initiated, it was initiated pursuant to what the Bush administration asserted was its authority to begin that program for the purpose of looking for terrorist footprints, if you will,
right,
in that matrix of billions of digital numbers collected by those computers. Since then, there's been a great deal of conversation back and forth and different movements by the Congress to restrict or condition that authority. I wonder if I might ask each of you whether you think we've reached the appropriate equilibrium and your view of that debate.
I think no. I think we've gone beyond what was the appropriate equilibrium. I am much more concerned here not about the overreach of the president, but the underreach of the country as a whole when it comes to authorizing data collection for intelligence gathering to deal with the subject of terrorism. I think there are things that the president had the authority to do that were constrained by Congress that didn't necessarily have to be constrained by Congress. Presidents are willing to abide by that. There's a rather elegant process in place, and I wish people appreciated the elegance of that process, the checks and balances that are involved, and the great care that's been taken to protect privacy. I think if you ask the average young person in particular, they'd say, oh no, our government wants all of our stuff and it can get it if it wants it and so on. That's just not true, and I think we've gone too far toward creating roadblocks to the gathering of data, which the government is only interested in with respect to terrorists or, under proper procedures, criminals. It just isn't interested in some 18-year-old's text to her boyfriend. That's just not the case. And too much law has been based upon the proposition that it is or might be.
So I was involved in the negotiation of the Patriot Act. This was actually authorized under Section 215 of the Patriot Act, which allows you to basically get records, business records. And metadata are business records of the providers. It's not like the safety deposit box that I talked about. This is like the bank records or the telephone company's records. And the bulk data collection was simply an application of 215. Now, there was a lot of controversy about whether this went beyond what the statute intended. They subsequently declassified the court opinions, largely declassified the court opinions, as well as some of the memos that were written to Congress. And I must tell you, anybody, this was pretty fully disclosed to Congress, to the relevant committees, and to the court. The court upheld it repeatedly. And the members of Congress, let me put it this way, it was available to them, and again, this is all declassified, it was available to them at the time in a classified setting to see what was being done. So, the kind of the scene out of Casablanca where they come in and go, I'm shocked, gambling, is a little bit like the reaction to the metadata collection. I will also tell you metadata collection is hugely useful because the rules, and I think John is right, the rules which no one showed were not obeyed, did not allow you to inspect the metadata unless you had a predicate to do it. But what you needed to do was to collect it so that you can have the haystack when you want to look for the needle in the haystack. Now, the current law changes that by having the metadata held by the companies themselves. I think you can live with that if you have two conditions met. One is you have to build a platform that allows you to search not only within each of the companies, but among the companies. And that's a technical issue. And the second is there has to be a requirement that the data be held for a certain period of time. Right now, I think as a matter of course, it's usually held for about 18 months or so. If someone were to say, we're going to not hold the metadata, we're going to immediately erase it after the billing cycle, I think that might be an area where Congress would have to step in and say, whoa. So in many ways, I actually view the preservation of access to metadata as more important from a security standpoint than the decryption debate, which is what's currently captivating everybody in Washington and Silicon Valley.
Thank you. I'm going to ask one last question, and then subject to Herman's guidance, open it up to the audience for further questions. And I'm going to take the prerogative to ask a question that's a little broader than the foreign policy and national security issues that we've been discussing, but certainly encompasses them. It is the president's principal responsibility to take care that laws be faithfully executed. If any president were to commit treason, bribery, or other high crimes and misdemeanors, the Constitution provides for impeachment and removal from office. Here is my question. Are there other remedies, short of impeachment, to ensure that the president upholds the duties of his office? And who has standing in court to challenge a president's overreach or his failure to take care that the laws be faithfully executed?
Well, the U.S. Supreme Court has raised that at least one, I guess the full court asked for briefing on the question, and this is in the immigration deferral of prosecution case, where the court has said, we'd like to have you also brief the faithfully execute the laws clause here. So I think we're potentially going to see some law made on that, but it will always raise some very interesting standing questions, and even if you've got somebody that can initiate the lawsuit, will there be a political question or some other justiciability factor that causes the court to withhold getting involved? It is not easy, let's put it that way, and I guess should there be other political remedies? Well, the only other political remedy is the accountability for someone in office, but again, if you're in the second term of the presidency, that's kind of hard too.
I agree with that. And the only thing I would add is, I guess if you get by the standing issue and the political question issue, I guess in theory a court could issue an injunction, although it's easier to have a negative injunction than a positive injunction. It's not clear to me to what extent a court could require you, like take the issue with the immigration. I'm not sure the court would have the power to issue an injunction saying you must deport people. On the other hand, the court might have the power to say you cannot give people a work authorization. And then, of course, the burden would fall on the lower officer, who, if the lower officer defied the injunction, would then be facing contempt of court. And I think, as you see with the Anti-Deficiency Act, often, putting aside the kind of atomic bomb of impeachment, the real leverage against the executive branch a court has is the ability to essentially pressure lower officers who don't get the protections that a president has in terms of their own personal liability.
Do we have questions? We have maybe time for one or two questions.
Someone over there.
Okay. Well, okay, this guy's a ringer, I got to tell you right now.
I apologize.
We're going to get graded on our answers.
That's right.
I really would like for each of you to re-examine a comment you made. Senator Kyle, in your case, you twice said that all legislative powers were vested in the Congress. I think if you read Article 1, Section 1, it says all legislative powers herein granted. And with respect to foreign lawmaking, that really comes under Article 2 and the treaty-making power, which the Senate has a negative, but this is really a presidential power. And Secretary Chertoff, you referred to the Keith case.
But could I just interrupt?
Oh, I'm sure.
If the president calls it a treaty, and the Congress, 2/3 of the Senate then has to agree to it. If the president doesn't call it a treaty, then he's gotten away with doing something. I don't know whether it's legislating or not, but it may be contrary to what the Congress had in mind.
The bigger point, though, was that Article 1 does not give all legislative powers to the Congress. The states have a lot of legislative powers. It says all legislative powers herein granted, so you have to find a clause in Article 1, Section 8 to justify saying what the embassy or what the capital of a foreign country is, I would think, which is what the Supreme Court ultimately held, 2 years ago. Secretary, you referred to the Keith case, and I thought you referred to that as saying that for the president to spy on foreign nationals in this country is regulatable by Congress or requires a warrant or something like that. Powell and Keith twice emphasized we are not making any decision on the president's power regarding foreign.
I was imprecise in that. Keith opened up the door to the FISA Act, which then ultimately did lay down requirements with respect to surveillance of anybody in the U.S. But I agree, Keith itself dealt with domestic security issues.
And I worked on FISA when I was a Senate staff member in '78, and in my view, Powell had clearly said we are not limiting the president's power. The FISA Court of Review in 2002 noted every court to decide the issue, but said the president has independent constitutional power to engage in foreign.
And I think Truong may have, in the Fourth Circuit, may have said a foreigner in the U.S. is not covered by FISA.
Yeah. Thanks. Hello, great program.
I second that. It was a great program. Do I have a last question out there? Otherwise, I'm about ready to, yes.
Sorry,
Yeah.
question. Back to the Guantanamo Bay issue. My name's Hillary. But back to the Guantanamo Bay issue with the whole standing issue. It's a question that my boss has had, and I know a couple people have raised it with him. If the president should decide to move detainees into the U.S. or even just violate the notification requirements, and the House were to file a lawsuit against the president, I've heard that the Congress would not have standing in order to pursue that lawsuit. What would your thoughts be on the House having that standing? Because you would have to show harm, all that kind of stuff.
I can't say I'm an expert in this issue. I think there's an argument that the House would have standing as a body. I think there's also an argument that perhaps an affected geographic area would have standing to raise it. And then again, at the end of the day, the Anti-Deficiency Act means a subsequent administration, if they chose to punish somebody for violating that law, would then be able to bring a case that way.
It's interesting that the court granted standing in this immigration case on what I thought was a pretty thin read, that a state would have to provide some educational and other benefits to illegal immigrants if they were allowed to stay here, even though they perhaps should have been deported, and would have the cost of having to issue driver's licenses or some such. So standing sometimes can be based upon a pretty thin read. And I think Congress, if a body were willing to vote to file the lawsuit, that would be a pretty direct, I think it would be hard for the court not to grant standing in that situation. But with standing, if you follow constitutional law, when you get fights between the branches, the court, and this goes back to the original point I made about deference, the court almost looks for ways not to get involved. So maybe they're standing, but maybe it's a political question. And they can just decide if it's a political question they don't want to answer, they're not going to answer it.
So I have standing to invite everyone to express their appreciation for the wonderful